UK Lawyers for Israel. You speak frequently on international law, foreign affairs, and national security policy. You hold law degrees from Oxford and Tel Aviv universities, and you were a fellow in the National Security Law Program at Columbia Law School. Before coming to the bar, you qualified as solicitor at Skagit and Arps, working in London and Brussels, and previously clerked for the president of the Israeli Supreme Court in Jerusalem, Chief Justice Miriam Nair. So after that introduction, we will get down to asking you some pertinent questions, and we'll see where the evening takes us. One of the first questions that I'd like to ask you is, what does international law actually say about the status of the territory beyond the Green Line? And I'm not sure, before you answer that you may just want to briefly explain about the Green Line and about being an armistice line, etc.
Absolutely. Perhaps if I start with the briefest of overviews of international law and what's relevant, particularly for this topic. There are two sources of international law which it's helpful if our audience is aware of.
Sorry, Natasha. Natasha, I beg you. Sorry, Natasha. There was a small glitch. Sorry.
No worries.
Go ahead.
There are two sources of international law that I think it would be helpful to have an idea of before we launch into the status of this territory. The first is treaty law, and for those lawyers in the audience, it really mirrors, or the best parallel in terms of domestic law is contract law. So when two parties enter into a contract and they sign on the dotted line, they bind themselves by what's in that document and they take on legal obligations. States do likewise in the context of treaties, and they can be bilateral between individual states, say two that sign up to a treaty, a contract like that, or they can be multilateral and involve many, many states signing up to the same text. The other source of international law is customary international law, and that's going to be particularly important at giving us the foundations of the status of the territory here. And there is within custom, which are principles of law that develop over a series of years, sometimes even 100 years. These principles are binding on all states without the need for them to sign themselves up to them, these principles, in the way that they would sign into a contract. You can sign a contract that deviates from those principles, but for the most part, these basic principles operate as a default. So where you haven't entered into any kind of agreement, it's customary international law that will paint the picture as to the legal situation. And it's out of customary international law that we get a principle that determines the boundaries of new states when they come into existence, so when they declare independence. It's a universal rule for determining the boundaries of those states at the moment of independence, and it tells us that those states take on the administrative lines of whatever previous existing administrative unit that was there before the Declaration of Independence. Now, the principle developed as a way of creating clean lines and avoiding territorial disputes by fixing the borders of new states at the moment of independence so there couldn't be any argument about them, and converting those pre-existing lines into internationally recognized borders so that you were working with the material that was already on the ground. Even those lines that were drawn by colonial entities without much thought for the territory or the peoples that lived there, even those lines which might have been arbitrarily drawn as part of the administration of those areas, that was the rule. And those were the lines that became recognized as the borders of the new states. Now, some examples close by to Israel of this principle being applied involve other mandates, including the mandate for Syria, the Transjordan part of the mandate which became the Hashemite Kingdom of Jordan, the mandate for Mesopotamia, which became the state of Iraq. The use of this principle, though, goes back much further than that. It originated in the 19th century in South America to avoid a vacuum occurring upon the withdrawal of the Spanish, so that there was a baseline, a fundamental legal status to work from when the Spanish vacated. It was later applied for similar reasons in Asia and in Africa on the withdrawal of European powers, and also at the disintegration of former communist federations. It's a universal rule. The doctrine is said to apply wherever this issue arises. It's even said to conflict with the principle of self-determination. And if there's interest, we can come on to discuss that principle in more detail later. Now, I suppose the big question here is, where were the administrative lines of the British Mandate? And at this point, and I know I haven't, no, I can't. I've just tried to share my screen to show you a few maps, and I realize I don't have that function here, unless the host at some point allows me that.
I will do that for you, Natasha. Just give me 1 second. That'll
wonderful. Because, and I'll explain in the meantime, if I show you those maps, we can see clearly where those administrative lines were, and what it is that the starting point is that we're working with. The Palestine Ordering Council of 1922 established the legal basis for the mandatory government in Mandate Palestine. And it explicitly excluded Transjordan from the application of that government. It gave the High Commissioner at the time, the British High Commissioner, discretionary power with respect to Transjordan. And if I try to share the screen again, it's working. So that the original setup that we're dealing with is a mandate that incorporates all of what is now modern day Israel, including the West Bank and the Gaza Strip, but also what later became the Kingdom of Jordan. Those were the administrative lines. Now, after that point, we move on to, apologies, it seems that the only way I can move through maps is by, still not, we'll get there. After that point, we come to this juncture, where in April, May 1923, Transjordan was granted a degree of independence. Abdallah was established there as ruler, and Britain creates a separate administrative entity that you can see here, called Transjordan in 1923. And it's at this point that the administrative lines change, and you can see this additional administrative line that runs along the Jordan River and down south, and it separates out into administrative units the British Mandate of Palestine, Transjordan, until 1946, where Jordan gains independence. So when I talk about the administrative lines of the British Mandate in 1948, it's this orange piece of territory here that we are discussing. Now, in 1948, Israel establishes independence, and it's out of that orange territory that it establishes independence. It's the only state to emerge from that orange administrative unit of the Mandate for Palestine. And the principle of uti possidetis juris, which has been applied in all of these cases as we've discussed, that universal principle dictates that the Declaration of Independence in 1948 is the critical date at which the territory of Israel is established, and those administrative lines become Israel's borders. That means that Israeli sovereignty, underlying sovereignty, under the principle applies across all of that territory at that stage, including the Gaza Strip and the West Bank. Now, we know we have the subsequent invasion of Jordan into the West Bank and Egypt into the Gaza Strip in the 1948-1949 Independence War. There are subsequent wars and ceasefires, and then Israel recovers that territory and some in 1967. But the important thing here is that from 1948, there are no agreements on any transfer of sovereignty, and all of the armistice agreements that we have in the interim are very explicit that they do not prejudice any final agreement on borders, and they do not speak to any international recognized borders, only the ceasefire lines, which were very simply where the respective armies stopped. Now, Maurice, you asked me to address the 1967 line or the Green Line. It is that. It is a ceasefire line. It is incorrectly referred to as the 1967 borders. As I say, Israel's armistice agreements and also to a certain extent subsequent peace agreements were very explicit that they do not constitute borders. It's also not dating from 1967, but in fact the ceasefire line of 1949 to which people refer when they say the Green Line. But it has no force in international law in terms of the borders of any state. Now, in the 1990s, Israel entered into agreements with the PLO to divide up administrative control in the West Bank, that territory that it had recovered from Jordan in 1967. And these were areas A, B, and C. A and B to be put under the territorial control of the PLO through the newly established Palestinian Authority, and Area C, to remain under Israeli territorial control. Again, all of those agreements have been explicit about not addressing issues of national sovereignty. They have been left open for final status agreements. So what are we left with? Well, we're left with the original general doctrine, the underlying principle that a new state incorporates all of the territory of the previous administrative unit because it adopts those administrative lines of the previous territorial entity. And that applies despite that territory subsequently changing hands through war. Another recent example of this, and it's the last one that I'll give on this explanation, is very briefly the situation with Ukraine and Crimea. Ukraine still has sovereignty in international law over Crimea, even though Russia has invaded it. And that goes back to the principle of uti possidetis juris, this general principle of international law. Because when Ukraine became independent, it took on as its internationally recognized borders the administrative lines of the Ukrainian Soviet Socialist Republic that existed before its independence. I hope that goes some way to answering the question, Maurice.
Thank you. We'll find out later on if anybody has any questions on that, but I think it does. So if we move on, what can you tell us about the use of the term, which I know you don't like, the term annexation, with respect to recent Israeli proposals?
So this is the debate that has sprung up in particular in the last few months with respect to a political proposal incorporated into the new coalition government agreement and to a certain extent foreshadowed in the Trump peace plan proposal to apply Israeli civilian law to certain areas in the West Bank in Area C. The reason I balk at the term annexation, perhaps I can approach it from this perspective, and I'll give you two very short definitions of what annexation means in international law from the most authoritative sources in terms of terminology. The first is the casebook of the International Committee of the Red Cross. It does a lot of work compiling international humanitarian law, which is the law of war, which plays a significant role here. And it defines annexation as a unilateral act of a state through which it proclaims its sovereignty over the territory of another state. Remember that and bear with me while we also look to another definition, this time from the Encyclopedia of Public International Law, which is published by Oxford University Press. Annexation means the forcible acquisition of territory by one state at the expense of another state. So both of these definitions are talking about well, in one sense, the seizure of territory through a unilateral act, in another sense, the seizure of territory through forcible acquisition, but in both cases, the territory of another state. And we can talk about or debate, if you will, the application of the principle of uti possidetis juris and what Israel's claim to the territory might be, what the underlying status of the territory might be. That is one part of the analysis. But in any event, to use the term annexation here is simply inapplicable when there is no other state that this territory could possibly belong to. The big debate currently at the International Criminal Court is that the prosecutor has been doing some legal acrobatics in order to find that the Palestinian people have a state there, not on any reasoned basis in international law, but as a matter of principle, because she would like to find a state on behalf of the people. She suggests that sovereignty rests in the people. But clearly, until the prosecutor has been launching into this particular analysis and this reasoning, which I should say is at odds with many state interveners who have written briefs to the International Criminal Court to say on no account would they accept that a state of Palestine exists. It does not fulfill recognized criteria in international law for it to be determined as a state. All of that aside, what we are missing here is any proposal that attempts to take another state's territory or incorporate that other state's territory into its own. Why do opponents of Israeli policy use the term? I think it's also become a shorthand. And I think a lot of people who don't really know any better and don't understand the principles of international law use it. But certainly people who should know better use it as well. And they do this on a series of false assumptions. I mean, the first false assumption is that Israel lacks a sovereign claim. The second false assumption is that another state holds sovereign title to that territory. And the third false assumption would be that when Israel is applying its civilian law as is proposed, or at least it's going to be considered at the 1st of July, that it is doing so on another state's territory. I mean, those three factors are incorrect. And the reason it's been able to take hold here, this, as Professor Avi Bell spoke recently and called it the rhetoric of international law on this very point, as opposed to the reality of international law. And the rhetoric of international law certainly holds great sway, especially where rules are made up in distortion against Israel. And that's actually, importantly, why you don't see these rules being applied anywhere else. One great way of working out if something is a general rule of international law, or if it's political manipulation of international law against the state of Israel, is to ask, well, where else is this principle being applied in this way? But I think the rhetoric of international law is sufficiently obscure to most people that critics of Israel are able to apply this double standard, able to apply these terms with no basis in legal reality. And it's easy for them to present this as something that the law backs them up on.
Thank you. So if there is this civilian law, what is going to be gained by Israel applying civilian law to particular areas of the disputed territory?
So I think what you have to understand as a starting point is that from 1967, when Israel recovered this territory, there was an anticipation that peace could be achieved by some agreement under which Israel would cede that territory. At that juncture, this was an analysis or a context, if you will, between Israel and Jordan, because the Palestinians weren't international players in the way that they are today, and Israel and Egypt with respect to the Gaza Strip. But we'll just focus on the West Bank here for these purposes. So what Israel does in the West Bank, excluding Jerusalem, because of course it's a caveat, but it's important to know that Israel does apply its civilian law in full to all of Jerusalem. And when it does so, Abba Eban actually writes, who's the foreign minister of the time, he writes to the UN Secretary General, and he explains what it is that Israel is doing in applying its Israeli law to the territory of Jerusalem. And he's explicit when he says this is not annexation. So it's a slightly separate point, but I think that's very telling in terms of the position that Israel sees its being in with respect to this territory. East Jerusalem was recovered in the same way that the West Bank was, and if Israel took the decision to apply its law in full to Jerusalem, did not consider it annexation then certainly a similar application of Israeli law to an even greater area of the West Bank would likewise not be in a concept of annexation. But I think the important thing to realize here is why Israel didn't do it at the time. And it was a political decision as opposed to a legal one. And so what you've had for the last 53 years is a kind of state of limbo. This was always meant to be a temporary situation until peace was achieved. And what has developed is a patchwork of Jordanian law as it applied in 1967, which incorporated some of the mandatory law that the British introduced and some of the Ottoman land law that the Turks had employed to govern the area before the British took ownership, in a sense, in terms of their role as mandatory. And that mishmash has been added to by Israeli military law. What Israel has done in not applying its own civilian law, it has said, okay, well, we are going to apply the framework of the international humanitarian law, which is purely military. It means that there are military courts that operate in the West Bank. And it does also mean that there is a divergence in some senses in the way that Israeli citizens living in Area C are dealt with under the law in comparison with Palestinians living there, because Israelis are subject to Israeli law wherever they are in the world. And so they, if they commit a crime, are liable to be tried in an Israeli civilian court. It is not allowed in terms of the framework that Israel has adopted, which generally speaking provides greater protections for the civilian population that is not a citizen of Israel. Those Palestinians living there are only covered by the military court system. So there are certainly arguments for equalizing the treatment of residents of those areas. There are arguments for ending this patchwork of law, which makes it incredibly confusing with respect to applications for permits. The fact that Knesset legislation does not automatically apply to these areas also means they are 53 years behind in terms of environmental regulation. And this has caused serious problems. There was a report in the last week of the Palestinian Authority. Their waste treatment and waste disposal and clean water are incredibly problematic issues in the West Bank because they lack this environmental legislation. But there's also a big issue with the Palestinian Authority dumping waste, which would otherwise be illegal. A report in the last week that 10,000 cubic meters of waste were dumped while the authorities have been dealing with the COVID-19 response in an area, in an abandoned quarry in the Binyamin area. So addressing environmental protections and those sorts of issues, but also welfare. So making sure that residents of these areas are able to have access to the same welfare benefits and healthcare that other citizens of Israel, or even residents of Israel, but living within Israel in areas where civilian law is applied in full, that they have access to. So the practical benefits, if you will, of a full application of Israeli civilian law are manyfold. But there are also potential benefits, I think, in the kind of political sense and the wider peace plan. But I might have gone on a little bit long enough, so we can always deal with those if there's appetite to.
Okay, so you're saying that there could be application of Israeli law, but what do you think this is going to do to international relations for Israel?
Again, it's an issue on which there's been a lot of debate recently. We've had statements, unhelpful statements, in my humble opinion, coming from the EU, one recently from our ambassador at the UN Security Council, the British ambassador, So far, it's incorporated this misstatement of international law, charges of illegal annexation, which have no basis in the actual legal status. But in terms of the question of what this will, what the impact will be going forwards, I hesitate to make predictions, but there's a part of me that feels that we've been through this movie before. I heard the same sorts of predictions, the same sort of rhetoric being used when the US embassy move to Jerusalem was being mooted, and recognition of Jerusalem as Israel's capital was being mooted. I heard the same protestations at a rather more extraordinary step, if you ask me, at the recognition of Israeli sovereignty in the Golan Heights. Now, of course, if we remember that the Golan Heights was originally Syrian territory, then it's not incorporated into original Israeli underlying sovereign territory under the principle of uti possidetis juris. There's a much more tenuous framework under international law that might give Israel rights to that territory. A lot of it is to do with defensible borders and maintaining peace and security. But despite these significant moves at the behest or at the encouragement, or certainly with the support of the US administration, and despite all of the bluster that we had in the run-up to them, the moment passed, and certainly there was discussion over it. Sometimes there were protests, but the predictions of this being the end of the world, of Israel being taken seriously in the international community, have simply not proved to be true. So in that sense, I don't buy it when it comes to the doomsday predictions on this. The question really is, could it have a positive effect in moving peace forward? And I suppose we've come to that question that I'd mooted a little earlier. And when you consider the position that the peace process is in now, that Mahmoud Abbas has said he can wait 100 years, that we have witnessed decades now of Palestinian intransigence, which is harming the Palestinian people far more than it is harming Israel, unfortunately, at the moment. That intransigence doesn't seem to be going anywhere. And when you have an international community that persists in rewarding it with a position that at each juncture Israel is required to improve on the offer that came previous to it, well, that's not going to do anything apart from encourage that intransigence to continue. So I appreciate your question was more to do with the impact on Israel's relations with the international community. I think that I'd hope that would remain largely unchanged, and even become more positive, because where states start seeing strides towards bilateral negotiations once again, then I can only hope that feelings towards Israel will thaw accordingly.
Okay, thank you, Natasha. I'm going to now open it to questions. I'm sure people will have lots of questions, though you seem to have answered everything. Maybe there won't be that many questions yet. We'll go to, you go ahead, yeah. Sorry, we're asking somebody to unmute themselves. Did we ask? Okay. Leonard or Heather, did you want to ask a question?
Yes.
Yes, go ahead, Heather.
Good evening, Natasha. That's been most interesting.
Hello.
I just want to tease out two things, if I may, which maybe I just didn't quite grasp as you were saying it, because it's complicated as it goes along. The first question is just two questions. The first one is the word annexation, which I appreciate now, really is misleading. I'd like to know what the Israeli government, do they use that word? And secondly, have I understood you right that Israeli civilian law, from what you're saying, could improve life for the Palestinians? And do you think that's the motivation of the Israeli government?
Perhaps we'll deal with that second question first. And I can say from the outset, I'm not privy to cabinet discussions on this. I'd be surprised if that was the motivation behind this proposal. I think the motivation is very much more political. I think to a certain extent it emanates from a serious degree of frustration. Now, having adopted this temporary state for 53 years, enough is enough. I think there is certainly a sense of that from elements of the government and also the Israeli public. Certainly Israeli civilians living in the area have been clamoring for this. And I should also stress that we don't know exactly what form this will take. So discussions are going to start on the 1st of July as to how best to implement this proposal of applying Israeli civilian law, where to apply it specifically, and also what status will be given to Palestinians living in territory that is incorporated by this application of law. There are a few, well, I'd say that the most obvious model is that which was applied in East Jerusalem. And this goes to answer the part of that question that you posed: would this actually improve the life of the Palestinians living there? And if that model is adopted, then the answer is absolutely yes. That model involved automatically anyone living within that area, any Palestinian, being bestowed residency. Now, that residency entitles them to welfare benefits, to access to the healthcare system, and a right to vote in municipal elections. What it also allows them to do is apply for Israeli citizenship. And that is a relatively straightforward process. It is open to any resident, and that is a feature that is common to most countries. It's not specific to Israel, but the procedure is determined by the Home Office, the relevant ministry in Israel. So if they become residents, certainly their lot is improved. And if they then go on to become citizens at some point, absolutely their lot is improved. They get to partake in the only properly functioning democracy in the Middle East. They are Israeli Arabs, and Israeli Arabs have risen to the highest echelons of the police service. They sat on the Supreme Court. They represent their constituents in the Israeli parliament and the Knesset, and so they have every opportunity and take full part in Israeli civilian life. And to a certain extent also in military life. There are a number of Arab Israelis who have risen up through the ranks very high in the army. So the lot would be improved enormously. The motivation, though, I think remains very much the Israeli government looking after the best interests of the state of Israel. The fact that that happily coincides with the best interests of the Palestinian people is not unique to this instance. In fact, many Israeli policies have benefited the Palestinian people far more than the policies that are followed by the Palestinian Authority. That is one of those unfortunate facts that doesn't sit at all with the way that things are generally represented. But if you speak to an awful lot of Palestinians off camera, they will tell you that that is the case. Many have also voted with their feet in areas that were marked previously, and this is with respect to Jerusalem, for the application in a similar fashion of Israeli administrative governance. This is to do with suburbs of Jerusalem that Israel had proposed extending its administrative system over. Palestinian Arabs actually moved into these areas preempting that administrative control being asserted, because they knew that their lot would be much better as residents of Israel in that territory than under the corrupt Palestinian Authority. And that is unfortunately a result of decades of corruption and intransigence. It's also part of the reason that Hamas was voted in originally with such popularity over the corrupt Fatah officials that ran in the only set of elections that Gaza has ever witnessed. So that was the second question. On the question of annexation and the term, if you listen, and unfortunately Netanyahu's speeches on this are often mistranslated into English, but if you listen to the terminology that Netanyahu uses in Hebrew, he does speak about the application of Israeli civilian law, which is mistranslated sometimes into annexation. He also and other Israeli officials speak about application of sovereignty, by which I would suggest that they also mean the application of civilian law. And that is the internal administrative change that they are talking about making. There is not a suggestion, so far as I can see in what is being discussed, that Israel is seizing territory or that this is part of some sort of land grab. Of course, the position that I've outlined in terms of what international law says as its basis, that Israel is the underlying sovereign here, that is not one that is necessarily advertised for diplomatic reasons by the government of Israel. And I think I can see the sense in that, because from 1967 to today, the position of the Israeli government has been that the only solution here is a political agreement reached through bilateral negotiations. Today, those bilateral negotiations are with the representatives of the Palestinian people. And in that sense, that underlying Israeli sovereignty from 1948 onwards is less important than what the end goal is, and that is a political question. The reason it's very important for us is because it's that underlying status that tells us what international law really says. And that is the position that makes it perfectly clear that these allegations of violations of international law and the term annexation is inappropriate. There are also many Israelis who use the term annexation who should know better. I mentioned that category of people before, and I think they make it very difficult and they cloud the issue. And that filters into the sort of political debates that we're experiencing now. And a lot of the time, again, it's used as a crutch or as a shorthand term for what is actually quite a complicated proposal that hasn't quite been formulated yet.
Thank you, Natasha, and thank you, Heather. We've a lot of questions and people are putting things into chat there. Could I ask the people who've got their hands up, their virtual blue hands, to please put their questions into the chat so we can choose, in case we run out of time, we can choose the ones that we feel are most relevant to the audience. But I will take David Erbach now. He had his hand up first. David? David, come in. David Erbach.
I should say I can't actually see any questions in chat, otherwise I might be able to read them out. My apologies, but there's nothing in mind.
Oh, they're probably coming in to me privately. Okay, we go to David Goldberg. David.
Good evening, Natasha, and thank you so much for the extremely learned and very erudite paper. My interest was perked up when you talked about administrative lines being established and not being redrawn, and you gave the orange map of Palestine as it was then as one example, and you also described how Crimea is still Ukrainian territory. Now, it seems to me that this is all very nice international legal speak, and I'm a lawyer, and I do know something about, a little bit about international law, not much, but a little bit. The real problem is that there is de facto a state of Palestinian people in two parts of the Israeli territory, whether they're governed by Israel and or Palestine or by Palestine is not really, it doesn't really matter a lot, because the world opinion is that this is Palestinian territory. This is run and organized by a Palestinian government, and that there seems to be one in the West Bank and one in Gaza. And it's a nicety to say that Israel's not really annexing anything. But the world opinion is that it is annexing. I don't know if you saw the leader in the New York Times, I think about this week or maybe last week, which was very critical of the idea of annexation. It said it would be a complete disaster. I think that David Rosen, who was on this channel a month ago, lives in Israel, also said that annexation would be a disaster for Israel. So it may well be that from a de jure or a de facto point of view, Israel could enter into administrative arrangements over some of the territories of what is, according to you, the state of Israel. But at the same time, this will not be acceptable by the international community. And an example of the non-acceptance of moves like the Americans to transfer the embassy from Tel Aviv to Jerusalem, it hasn't made any difference to Israel. It hasn't persuaded anyone to join and to follow the Americans in any great numbers. There's only been a few small states who've followed suit. So isn't there a huge divide between what you call the legal opinion and the international opinion, which conceives international law in a very political way and in a very different way to the de jure sense of law?
So what you throw into stark relief are that there are two issues at play here, or two groups of issues. The first, legal, but the second, and in your opinion, I'm guessing far more important, are the political ones. But the former are being used, or I should say abused, to support the latter when arguments of violations of international law are deployed to buttress that criticism of Israel. Now, just because everybody says doesn't make it true, and it certainly doesn't make it international law. And I mentioned earlier that the key test here, especially when one is faced with the position of everybody says, is to say, well, what is the position generally speaking? What general principle of international law are you applying to Israel to demonstrate its violations, and show me where else it is applied? And a fundamental principle of international law is that it is universally applicable. There cannot be one rule that says X for Israel because it is the only Jewish state, and then the rest of the world is governed by rule Y. That's just not how international law works. It's also not, just as a matter of common sense, how any legal system or any legal system that ought to have respect should work. To the issue of there being a de facto Palestinian state, again, it's one that I would push back on quite strongly, not least because the Palestinian Authority is utterly inconsistent as to whether they are claiming to be a state or not. Interestingly enough, they apply at the International Court of Justice and also at the International Criminal Court in the same period. So they have two applications running concurrently on cases and say completely contradicting things on whether or not they are a state. But again, there are fundamental principles in international law that help us with these questions. And the criteria for statehood are set out in the Montevideo Convention. That is a set of criteria that, as many scholars argue, has become accepted into, again, customary international law. It is on that footing of international law. And the Palestinians simply do not qualify under those criteria. A permanent population, a defined territory, a government, and capacity to enter into relations with other states. Well, the fact that you describe in your analysis two separate population centers, one governed absolutely by a dictatorial, genocidal terrorist regime, Hamas, that treats their own people despicably, let alone what they would want to do if they got over the border into Israel, and the other in the West Bank by that corrupt regime under Fatah, the Palestinian Authority that I described, that also haven't had a way past the elections that they ought to have had. the fact that they're not democratic is neither here nor there for these purposes. The fact that these are two very distinct population centres, there is no unity between them, there is no single government, and there is no defined territory, let alone having any sense of effective control over that territory, as was required, for example, for the application of certain kinds of jurisdiction. So that is something that I think it's another one of these misnomers, it's another one of these misrepresentations in international law, just because the Palestinian Authority stamps their application to the International Court of Justice, the state of Palestine, doesn't make that so in international law. There are frameworks and structures and criteria out there to obviate these very disagreements. The fact that they are consistently not being applied to one state, in the case of Israel, I think tells us, could potentially tell us a great deal about the motivations behind those making these exceptions and generating these double standards. I hope that.
Thank you, Natasha. So you were saying the law is the law, and it shouldn't not apply to Israel, if I understand you correctly. David Harris, you'd like to come in?
Yes, thank you, Maurice. First of all, I just want to say what a wonderful presentation we've heard tonight, and it's been so clear and so informative. Thank you, Natasha. I just want to refer back to the comment you made about the Golan Heights. And if my understanding is correct from what you said, this would constitute an annexation of that particular territory. And then the subsequent recognition of that territory seems to me to be a problem. And my question is, do you feel that in any way this undermines the defense of Israel under international law with regards to its territory?
So I think the legal questions and the legal analysis on the Golan Heights is entirely different from what we've been discussing so far in terms of Area C in the West Bank. But that doesn't necessarily mean that Israel doesn't have a strong case for it. It's just different. The key issue here, as I indicated, is that it was originally Syrian territory, which was captured by Israel. And the big argument that arises from Israel's holding of this territory is a question as to whether or not one may acquire territory in a defensive war. There is an absolute prohibition on, well, I shouldn't say absolute, there is a prohibition on the use of force and it's often referred to in the Charter of the United Nations, Article 2.4. And it is linked to force that interferes with political, well, which we say territorial integrity of another state, which obviously the Golan Heights coming from Syria to Israeli control clearly does. But that the use of force has a fundamental exception to it. And that is found in Article 51 of the UN Charter, which recognizes, it doesn't create, it recognizes an inherent right to self-defense. Now, scholars argue that that right to self-defense is so fundamental and is so innate to each individual state. It's not up to the Charter to set it out for those states. The Charter merely recognizes it. So then the question as to the acquisition of territory, whether it's considered legal or not legal, boils down to, well, what is the difference between acquiring territory through use of force, which is in contravention of Article 2.4, illegal in international law, and what is the result if that acquisition of territory is acquired through lawful action, through self-defense, as in Israel's case when it was attacked by Syria from these areas. So that's one part of the legal analysis. Another part of the analysis on the Golan Heights is arguably more political, but I'll explain how I think it links into the driving force of international law. And that is to do with defensible borders. So that is something that even the United Nations has recognized is important in Israel's circumstances, not least because it is faced with so many threats from its neighbors. and because of the situation before the Golan Heights came under Israeli control, where the kibbutzim in the Galilee area was subject to sniper fire coming from that Syrian-held territory. There's that aspect of it, and there's the practical issues as to what have happened subsequently. I think part of the reason you don't hear many people clamoring for Israel to return the Golan Heights to Syria is because people have seen what has happened in Syria over the last decade. And I think even the worst critics of Israel would recognize what a disaster that would have been if that territory was still outside of Israeli control, given what has been happening in Syria, and if those Israeli communities were still under threat from the high ground in that fashion. And so the way that I think those political considerations of defensible borders play into considerations of international law is this: the driving force behind international law is achieving stability and promoting peace and avoiding conflict. That is why uti possidetis iuris became so fundamental in terms of how new states came into existence, because there was that certainty. In the 1984 case of Burkina Faso Mali, where the International Court of Justice goes into detail in this principle, it was at great pains to explain how important this principle was in obviating territorial disputes, what it called fratricidal struggles occurring at the birth of new states, squabbling over territory where there wasn't that clarity. And so similar principles, similar considerations apply with respect to Israeli sovereignty over the Golan Heights. And when you think about, this links into a little bit into the discussion that we were having earlier about, what will the international community say? For better or for worse, the driving force on the current disputes in the Middle East and the peace process, if we can still call it that, is the United States of America. And so where you have the United States leading the way on recognizing Israeli sovereignty for all of the reasons, some of which I've outlined that were discussed in the committee hearings in Congress that occurred before this decision was taken, that sets a standard, an international standard that the international community tend to, if not fall into line with, at least don't voice significant opposition to. And I think there will likely be similar factors at play to the extent that whatever happens in terms of the application of Israeli civilian law in Area C, to the extent that that has the backing of the US administration, and there have been indications most recently from Secretary Pompeo when he went to visit Israel despite all of the COVID restrictions, that this could in fact set the tone for the way the international community responds to this as well.
Thank you, Natasha. Yankee, you have a question?
Good evening, Natasha. Can you hear me?
Loud and clear.
Oh,
I can't see everyone, I'm afraid. I keep
That's all right. That's all right. Natasha, we have a close, Israel has a near neighbor.
Mm-hmm.
It's called Cyprus. Not very far, just across the sea. And Cyprus was invaded, and the sovereign island of Cyprus is now split into two. Why is no one really talking about what Turkey has done in Cyprus, which seems to be far worse in terms of legal precedent than what's happened in Israel?
Your guess is as good as mine in terms of the motivations behind that, but it's not the only example of double standards and a complete misapplication of international law. It's not even a lack of consistency over the way that it's applied. It is a complete divergence. In fact, on the question of settlements and the legality of settlements, there is a fantastic paper that has been put together, which I can send to Maurice and he can distribute to anyone who's interested, by Professor Eugene Kontorovich, that analyzes basically the issue that you're describing, allegations of Israeli settlements being illegal, and compares it to instances in East Timor, in Western Sahara, in Northern Cyprus, specifically addressing this issue. It also looks at the Syrian occupation in Lebanon. It looks at what happened with Vietnam and Cambodia, in Azerbaijan, with respect to the Nagorno-Karabakh region, and also with respect to Russia, both in Georgia, in Abkhazia, and in Ukraine, in Crimea. And this article gives you the answer, I think, that you're looking for, which is that in each of these cases, there has never been any discussion of what is real settlement activity that arguably breaches international law on the transfer point, which is what people use to claim that Israeli settlements are illegal. It doesn't apply to the Israeli settlement enterprise, in my respectful opinion, for a number of reasons. But it's interesting that in all of these cases, which actually do tick the box in terms of international law, suggesting that under the Fourth Geneva Convention, under Article 49.6, that this constitutes an illegal activity, and no one, no state, no international organization, no human rights organization has ever called out this activity as being illegal. I should say that there is one exception to that, and it relates to the example that you raised, because with respect to Northern Cyprus, the Republic of Cyprus is the only state that has described that settlement program as a violation of the Geneva Convention. Otherwise, it's universal that this isn't picked up.
Thank you, Natasha. I hope that answers your question, Yankee. There's been a few questions that I want to ask you, Natasha, that have come through in the chat. Somebody has asked, might this proposal speed up the potential for a peaceful Singapore-like state in Gaza?
So Gaza is a completely different kettle of fish, and I should have been clearer that when I was talking about potential positive impacts on the peace process that we're currently discussing, that really is only between the Israeli government and the Palestinian Authority, representatives headed up by Mahmoud Abbas. My personal opinion, I don't see that there is any start to any potential discussion with Hamas. It has become a terrorist state, if you will. There is no desire from the Hamas rulers there to enter into any dialogue with Israel. At least the so-called moderates within Fatah and the Palestinian Authority, there's no desire on their part to come to the negotiation table now either. At least their rhetoric is directed towards seeking some sort of solution with Israel internationally, even if domestically they maintain the line of from the river to the sea, there will be no Israel. They maintain education from kindergarten up in schools and indoctrination to seek the eradication of the state of Israel. And that is, as unfortunate as that is, as much as they support terrorism and continue to fund terrorism, they are at least in the camp of those individuals that that potentially might discuss peace with Israel at some future date. Gaza is a different story. And so I'm afraid I don't have any answers for that. But it goes to show, I think there is an important lesson that we can learn from Gaza. Because of course, the takeover of Hamas was facilitated by the elections which the United States presided over in the Gaza Strip. And that followed Israel's unilateral withdrawal from the Strip. And that is a lesson, I think, in terms of, at the time, Israel was hopeful that the Palestinians would be able to do as they had indicated. They would build their own governmental structure there. They would build a flourishing society. In fact, when Israel vacated the Gaza Strip, they left industry behind. They left greenhouses, agricultural industry, which was then just immediately destroyed by the Palestinians once the Israelis vacated. So there are definitely lessons that we can learn in terms of that can replay in the West Bank. And if you have Hamas taking control in the same manner in the West Bank, it's a completely different story, because it's not just missiles onto the south of Israel, which, as unacceptable as that is a reality that Israel as a whole, it seems, has come to live with now. But it would be Jerusalem under threat, Tel Aviv under threat. Actually, it might be worse. I don't know how many people are familiar with the geography of the place, but if I just bring up an image of the West Bank here, you can see how close Tel Aviv, Jerusalem, Netanya, Hadera, even Kfar Saba are, and how narrow indeed the middle of Israel is when we're looking at this area of the West Bank. And in fact, when I was talking, I know we're going slightly off piste here, but when I was talking earlier about areas A, B, and C, you can see them demonstrated here on this map. Area C in this turquoisey color under full Israeli control. Area A is where you have the main population centers, the main Palestinian population centers, and you have entire control by the Palestinian Authority there. Palestinians living there, they vote theoretically for the Palestinian Authority. They are represented by the Palestinian Authority, and they are governed by the Palestinian Authority. That's taken a slightly off piece from the original question, which was Gaza, but I pivoted really to say that I think we ought to learn the lessons of Gaza. The international community, Israel's learned the lessons of Gaza. The international community needs to learn the lessons of Gaza and to recognize what it is that Israel is potentially up against. And the last thing I will say on this goes to the question of security cooperation, which I appreciate hasn't been raised, but it's a big issue at the moment. It's been a bone of contention, with Abbas saying that he's throwing away the Oslo Accords and he's ending security cooperation with the Israelis. The really important thing that I think everyone needs to remember about that is that Abbas relies arguably far more on Israeli security cooperation to prevent that Hamas takeover that I described in the Gaza Strip, where they seized power and threw their opposition Fatah members off of the roofs of buildings. To prevent that same that same scenario occurring in the West Bank, Mahmoud Abbas and his Fatah colleagues rely on Israeli security cooperation to prevent a Hamas takeover. So I think, again, we need to view threats like that coming from the Palestinian Authority in the proper context, and also the context of these threats having been made many, many times before and not been followed up with, principally for the reasons that Abbas would likely be the first casualty if in fact Hamas were able to establish themselves once he'd ended security cooperation with the Israelis.
Thank you, Natasha. Just two quick questions that have been put into the chat. Did Jordan purport to annex the West Bank before they lost it, before 67?
Yes, they did. They did, and that annexation didn't get wide international recognition. It was recognized by the United Kingdom and it was recognized by Pakistan. But again, those questions about illegal annexation, they would apply to Jordan in that context, annexing or purporting to annex territory which fell to Israel in 1948 through the principle of reciprocitatis juris. So therein we've got, the perfect example, in the same way that, well, I'd say there are basic similarities between Russia invading and taking Crimea and Jordan taking the West Bank in that fashion.
Thank you, Natasha. And just to come closer to home, there's a question: does this mean, I'm not quite sure what this applies to, does this mean that the proposed Occupied Territories Bill is essentially illegal? You're familiar.
I am familiar with the bill. The bill, I don't know if it's going through different iterations now. I appreciate everything's shifted with a change in Parliament, and things start from the beginning. My reading at the time that the Francis Black Bill was being proposed indicated to me that it misstated international law, that it didn't apply international law properly. And I think in the terms of the question as to whether it's illegal or not, the key issue there is what does European legislation say about the ability of Ireland to determine economic policy in that fashion. And from memory, that is where the Francis Black Bill ran into difficulties. And in that sense, what is currently being discussed in the political proposals of applying Israeli civilian law don't change the difficulties, the problems that existed with the Francis Black Bill. And it's unfortunate that that bill has been spurred on by the sorts of misrepresentations and misnomers that is increasingly circulated in the international community under the guise of international law.
Natasha, I'm going to try and ask everybody to unmute themselves, because since yesterday, second one from the top, since yesterday with Zoom changing their software, if everybody could just unmute themselves. And Natasha, thank you so much for being with us. I think people have learned an awful lot, and I'm sure everybody is showing their appreciation.
Perfect. Thank you so much for having me. Wonderful that you've all been so eager and have stayed, stayed all of you for such a long time. I appreciate it's perhaps not the most, well, it can be a bit dry, the subject, but I'm very grateful that you take an interest in understanding the underlying situation.
Thank you, Natasha. I think we had about 70 cameras on at one stage, and which is probably about 100 people, maybe even more. And I hope that we'll see you again.
Take care of yourself and stay safe and well.
Thank you. See you soon. Bye bye. Bye bye.